Good afternoon, everybody. My name is Chris Justice, and I'm back again with you to answer hopefully as many questions relating to employment law as I can. I'm working out of Samfiru Tumarkin's Toronto offices, and as I say, every day or every time I come here, I try to answer any questions relating to the workplace. Could have to do with maybe a contract that you have a question about. Maybe it has to do something with your boss. Maybe you're experiencing some issues in the workplace. Perhaps also you've been let go and you're wondering about, whether or not the severance package you've been offered is fair and reasonable, whether you should sign a certain document that your employer is asking you to sign. So could be anything going in during or after the employment relationship, but definitely get your questions in. And as I say, I'll do my best to answer as many as I can. I do also typically start with some topics at the top of the half hour today. That today will have to do with, number one, the amount of layoffs and terminations that are continuing to happen. So we are continuing to notice the trend where across multiple different sectors, companies are letting people go, they're laying people off. Could be part of a mass layoff, could just be a one-off, but a lot of people, as I say, are losing their jobs and they're wondering whether they're being offered a fair severance package. They're wondering whether they're owed anything on top of that severance package. But I think above all else, just making sure that they're afforded a reasonable and fair package. And the fact of the matter is that regardless of who you are, there is a very, very strong chance that if you have been laid off, you have not been offered a fair package, and you absolutely should contact a lawyer, get some legal advice before certainly signing any documents. Doesn't matter what industry you're in. And in fact, if you're in an industry that's been hit quite hard and there are more limited opportunities now available out there, that could be something that weighs in your favor. That could actually be a fact that offers you the ability to get even more severance than if you were let go or terminated during a period of more economic prosperity. So as I say, regardless of the situation, if you're part of a mass layoff or not, but you've been let go, you've been told maybe that it's because there's been a restructuring, reorganization within the company, and you've been offered a package, you want to give us a shout and definitely talk with us before signing anything so that we can make sure you at least get your fair severance owed. It's possible for individuals in Ontario and actually countrywide to get 24 months of severance. And a lot of people have a mistaken belief that, the company only owes them maybe a week, maybe 2 weeks for every year they've worked, when more often than not, it's closer to a month or two for every year they've worked. So again, you want to get advice, but if you are part of these mass layoffs, give us a call. The other thing I wanted to talk about as well is that, there are also situations where you're not let go, but where your employer is making certain changes to your employment. Maybe they're asking you to pick up an extra shift. Maybe they're asking you to put in more hours each week than you have been normally. And a lot of people will come to me and ask whether or not they have the right to decline that, to tell their company, to tell their employer that they did not sign up to, work these extra number of hours, or that they did not sign up to take on these extra duties, that these are things that are just being essentially pushed onto them. And if there is a big enough change in that sense, employees do have the option to consider a scenario like that as though they're being terminated. It's what's known as a constructive dismissal, where significant changes have been made to the terms of your employment that you don't agree with. But before taking any action or before communicating with your employer to any large degree, if you are facing certain changes, you want to get in touch with us. You want to get legal advice so that you know exactly how to respond to your employer as well. There can be some sticky situations where an employee may say something to their employer that doesn't exactly help their case or doesn't put them in a position to have more options open. So that's why getting legal advice as soon as possible when it comes to your employer making changes to your job is very important. And again, that could be a change with respect to the hours you work, the scope of your duties. Maybe there's changes happening to your bonus plan, your compensation. It could be a number of different changes. It's not always that the change is big enough, but just so that everyone knows, that's another scenario that a lot of employers are putting their employees through. As I say, if you're not getting let go, then certain change is going on. And a lot of people also are asking, if they don't do this extra work, what can happen? Can the company terminate my employment if they don't accept the fact that I only want to do what I signed up to do? And generally speaking, companies can terminate you for pretty much any reason they want. But if they're going to terminate your employment, they, in all likelihood, will still have to give you a fair and reasonable severance package. And again, that's where the legal advice will kick in. So those are two of the sort of trending topics I wanted to talk about initially. As I say, if you're part of a layoff, want to get advice before accepting any severance. And if you're being confronted with changes in the workplace, maybe due to external factors, whatever it is, you want to get legal advice so you know best going forward what your options and what the possibilities are. Now, I've got a question before I talk about a little bit other things that have been trending in the news recently. I've got a question on YouTube. The question involves someone who was fired after 23 years for willful misconduct. The company didn't even give this person a chance to explain the situation. And it's being said that they went back 2 or 3 years to prior written warnings and a 3-day suspension, but no severance was offered. And the person is asking, what are my rights? So first of all, if you have been terminated for willful misconduct and your employer is saying that for that reason, they don't have to provide you with any severance, then you should immediately be contacting a lawyer, because it is extremely difficult for employers to actually get away without paying somebody severance. You have to have engaged in, a very, very serious incident or a number of incidents before a company would have any chance to get away with not paying any severance. And there does have to be documentation. The company has to give you warnings. And it's not sufficient if maybe there's just 1 or 2 warnings. It really does depend on the situation. So even though your employer is saying they have willful misconduct and that they're not offering severance, and they spoke about a written warning that happened 2 or 3 years previously, which is a long time ago, it's likely that your employer still owes you money, and especially after so many years of service. The employer is going to have an even harder time getting away without paying somebody severance if they've been at the company for, in this person's case, 23 years, which is very long. And so really the potential for this individual, having put in 23 years, is to get 24 months of severance, which is a huge difference, obviously, from the 0 that they're being offered by their employer right now. So it just goes to show, again, how important it is to get legal advice, because it could be the difference between you literally getting nothing or upwards of 2 years of compensation in terms of your wrongful dismissal damages. So if you're someone in a situation where there's been this allegation of willful misconduct, maybe you think that you don't have any case, maybe you think that you've done something wrong. The thing is also that you could have done something wrong, and that still doesn't mean that the employer can get away without offering you anything. It can be the case that a wrongdoing has happened and not necessarily mean you have no option. So whether or not the allegation is true, again, you want to give us a shout because you shouldn't be assuming that you're dead to rights and that you have no severance entitlements there. But it's a good question, so thank you for that. I've got another question from Art Miggs on YouTube, who's asking how long should a company provide you to sign a severance package? Is there a minimum amount of time they need to give you? So oftentimes what happens, somebody gets let go, they lose their job, they've been told that they're being terminated on a without cause basis, and they're being offered a severance package. And then when you look through that severance package, you see that there are sort of maybe 2 different categories. The severance amounts that the company owes to you by law, which would be the amounts under the employment standards legislation. And then they'll often add an additional amount on top of that, but you have to sign a document, a release, and usually they give about a week for someone to sign the release. So if, let's say, you're being given a week or 2 to sign a severance package, and you don't end up signing that severance package, you are still going to get what you're owed by law at minimum. Again, the amounts that would be set out in the employment standards legislation. So, for example, for a 10-year employee, your minimum amount of severance could be in the ballpark of 4 months. So using that example, you would still get 4 months, but say your employer offered you an extra 4 months, but you had to sign this piece of paper. There's no strict deadline as to when that needs to be signed. It is an offer being given by the company, but people shouldn't think that they need to sign a package before that deadline, especially considering that most of these packages are not fair to begin with. You're going to want to negotiate for a better package. And by doing so, in essence, what you're saying is that I don't accept this package. This is what I want instead. So there's no set minimum amount of time. Employers can give somebody a week, 2 weeks, a month, a year. It's sort of up to them, but that doesn't change what the law says that person's owed. And definitely you don't want to sign a severance package thinking that the last day you have to sign it is, a day or two from now, because you're going to end up likely throwing away potentially thousands or tens of thousands of dollars. So either way, if you get a package, get into touch with a lawyer, get some legal advice. If anything, the lawyer can ask for an extension to respond to the offer. Or sometimes I'll even say to the client themselves, why don't you send them an email, the employer, and say, look, I know you've given me a deadline of this day, but I would appreciate it if I could have an extra week to review and consider my options. And in 99% of the cases, the employer says, yep, that's fine. We'll give you some more time to consider. And in that interim period, you can get in touch with a lawyer, get legal advice, and there won't really be any effect because, as I say, you're going to want to negotiate, most cases, a better package to begin with. So you don't really want to sign that. Otherwise, you're going to be giving away the money that I mentioned. But it's a good question because I know a lot of people I speak to, they get these packages, they see a deadline, and they start to panic. They start to freak out and think, I'm not going to even get that amount if I don't sign it. But more often than not, what ends up happening is negotiations occur and the number itself actually goes up. And the company then settles with that employee maybe a month, maybe 2 months down the road. But that's sort of a starting soft deadline that they'll often impose, but not to worry, I don't think. But thanks for the question again. I've got some other, I got a few sort of comments or questions from Raccoon on YouTube. So they're citing the Canada Labor Code. The Canada Labor Code, and they're mentioning that it is unclear when it comes to, I think, a fixed term contract. So there was a contract, it seems like, that lasted from October 21 to March of 22, but then employment actually continued after that fixed period of time. So it sort of, I guess, turned into an indefinite period of time. And if somebody has a fixed term contract, let's say for a year, and they just so happen to work past that year or past that 6-month period or whatever, and there's nothing else that's signed, that employee is, like I say, looking probably like an indefinite employee. And so their termination rights are going to sort of be in line with what an employee under common law would get. So if someone is let go maybe a year and a half into employment, maybe 6 months after the fixed term ended, they could be getting 3, 4, 5, 6 months of severance. Severance, by the way, is not just based on the Canada Labor Code. It's also based on something known as the common law. A lot of people think that what they're entitled to under the Canada Labor Code or under the Employment Standards Act, which is the legislation in Ontario, they think that that's all they're entitled to. When in actuality, they're often looking at much more than that. So, sorry, Raccoon, that's just one point I wanted to make, where fixed term contracts end and people stay on after. It's going to be very difficult for that employer to sort of rely on that fixed term contract if nothing else is signed and there's nothing new done there. But another question that Raccoon had was whether or not they're entitled to vacation. And they are. If you're an employee, whether you are a federally regulated employee or a provincially regulated employee, or at least work for a company that's regulated in those areas, regardless, you're going to be owed vacation pay. The minimum is typically 4%, but it can go, much higher than that, go 6, 8, 12. I mean, I've seen employees that get 15% of vacation pay, but it would depend on what the contract itself says. And vacation pay, whatever percentage it is it is sort of accruing based on the amount of wages you earn. So if you start a job January 1st and you work for the whole year, you're going to get at least the 4% vacation pay in terms of general entitlements, but even more than that. So your vacation pay should be retroactive in the sense that if your company hasn't paid the vacation pay or anything in terms of vacation pay to you, it has to be paid at some point for sure. Sometimes your vacation pay gets attached to each paycheck you get. Other times your vacation pay gets paid near the end of the year. But you definitely want to make sure that you're getting the right vacation pay. And I would just ask the employer to clarify, what they have paid towards vacation pay if it's not really clear, and just to get them confirming what percentage they're paying out at, because they're going to want to provide that clarity in any case. Otherwise, you might have a claim against them for owed vacation pay, which can be done through the help of a lawyer or also potentially through the Ministry of Labor. You mentioned as well, Raccoon, that the Labor Code states there's after 3 consecutive months, the employee is entitled to medical leave. Employees are entitled to leaves, especially after completing a certain number of time with the company. So if you are also in a scenario where you're asking for medical leave and it's being denied, that is potentially an issue there. I've got another question from Richard Roper on YouTube, who's asking what happens if you're recalled back to work after hiring a lawyer for being laid off? Does the court, does it count against you in case you return? So this is something that happens not too infrequently. So somebody maybe makes a claim that they are owed to severance, they're owed to wrongful dismissal damages due to being laid off, and they bring a case or a claim against the company. And then the company in response tries to recall that person back, at least partly because they want to do that from a strategic point of view. Being able to show that you call an employee back when they're arguing they shouldn't have been laid off, or the employer didn't have the right to lay them off, could potentially give the employer an added advantage. So oftentimes they do it for that, not necessarily because they want that person back, which is unfortunate. But the thing too is that once you've actually hired a lawyer and possibly even commenced litigation, it's going to be less reasonable for someone like that to go back. So it does count, or I guess it can count if they try calling you back, but it just depends on the circumstances. It depends on how long maybe they waited before calling you back, depends on whether or not you've actually commenced a lawsuit. And it also depends on whether or not the employer has the right to lay you off to begin with, because there could be a contract that you've signed that allows them or gives them that right to lay you off. If they don't have something in writing from you or signed from you allowing layoffs, then they wouldn't generally be able to. But yeah, it's sort of hard to answer with more preciseness on that, Richard, only to say that it can count against you. Oftentimes it doesn't have the biggest effect in my experience, but yeah, depending on all those variables, it can affect you to some degree or another. If you have hired a lawyer, I definitely ask, for that information from that lawyer, based again on the circumstances of your case. We got another question from Raccoon, maybe a follow-up to the previous, asking, can an employer require flexing shifts, working 10 hours one day and 4 the next to avoid overtime? Again, federally regulated company. And can the company's HR manual be more restrictive than the labor code? So first of all, the labor code or the Employment Standards Act, whichever piece of legislation we're talking about, or the Occupational Health and Safety Act, will set out the bare minimum requirements when it comes to certain HR policies. Like maybe there's an anti-harassment policy, policies along those lines. And a company cannot put out a policy that is, I guess, less favorable to employees than what's being offered or provided for in the legislation. And so it seems like, based on what you're saying, Raccoon, they might be putting forward a policy that falls below the standards of the code. And if so, that can be an issue. So I think it would be a matter of pointing out what the particular issues were, how it falls below what the bare minimum entitlements are. And again, this could be the labor code, this could be the Occupational Health and Safety Act. It could be a number of different pieces of legislation, but that would be something to look into for sure. The employer having the ability to have flex shifts where you work 10 one day and 4 the next, it will, I think, in part depend on whether or not you've signed any kind of a document or there's sort of any written understanding that your employment is subject to flexible shifts. So if somebody, for example, is working 9 to 5 and they've signed a contract saying I'm working 9 to 5, and then all of a sudden this flex shift arrangement sort of suggested, that's going to be a big change. That's going to be a significant change and likely amount to a constructive dismissal, in which case you as the employee could take your stand and say, no, that's not what I signed up to do. On the other hand, if there's, as I say, something you've signed that might allow for the employer to sort of impose this shift arrangement, then you may not have as much leg of a leg to stand on, and it may not be a big change to the terms of your employment because it's actually been incorporated into your employment already. So I think it would depend on that. Now, of course, if an employer is trying to avoid paying overtime, there are definitely situations where that could be seen as being done in bad faith. But I won't say in all cases that's the case. So there's a potential bad faith claim there, but I think that would just involve digging in a bit further into your situation, Raccoon. So if anything, I would say it might be good to give us a shout, only because you've got a number of issues going on or questions, whether it's to do with overtime, flex shifts, the HR manual, as well as the vacation issue that we would want to clarify. But yeah, hopefully that's a start at least. And as I say, get in touch with us to get some more advice. I've got another question in from Sonics on YouTube who's asking what the difference is in severance between a non-union and a union. Sonics is saying they've heard union jobs say they owe you 2 weeks for the first year and 1 week for every year after that worked. So what I will say is that I myself practice non-unionized work. So when it comes to severance packages in the non-unionized sector, I can definitely advise you what the potential is. Earlier, I said that if you're a non-union employee and you've been let go, you can be entitled to upwards of 2 full years of severance. Now, there's no exact science or rule. It'll depend on the situation. But a lot of times in the non-unionized sector, you're looking at between a month to 2 months for every year you've worked. And based on what you're saying, that definitely seems to be more beneficial. But when it comes to the union side, you are a part of that. If you're a unionized employee, you're a part of the collective bargaining unit. You're part of that union. You've got that collective bargaining sort of agreement. That agreement is going to set out what you're owed. So anytime a unionized employee typically comes to me and asks me a situation regarding their matter, I first tell them that I don't specialize in that. But I also say, talk to your local union rep in terms of where they're coming from with that severance payout. And if you need to as well, consult the collective bargaining agreement because that should have some section or some language in there that speaks to what happens in the event of a termination or what happens in the event of severance. That would be the starting point. And in all likelihood, you're going to have to go with what the collective agreement says. But, to the extent you have any other questions, I would definitely recommend just getting in touch with your local union rep and hopefully they can take it from there. I've got another question from Rick Guthrie on Facebook who's asking or saying that they worked 6 years as a GM, a general manager for a not-for-profit, as an independent contractor through their business. They were let go. Rick was let go suddenly with no explanation and a huge amount of back pay owing. It's been 5 months with nothing so far, and he's in the process of now suing for the back pay, asking if he can go for severance as well. And definitely, Rick, it is entirely possible you can go for severance. I know you mentioned you worked as an independent contractor. I know you've mentioned that you have a business that you maybe send invoices through. And you may think that that means you're not an employee. But in very many cases where those things are all true, the employer, or I should say the individual, is still considered an employee. It's not you or the company that determines who's an independent contractor. It's the law. And the law will look at not just whether you have your own business or what labels attached to you or what contract you may have signed that says you're an independent contractor. The law is going to look at the relationship you actually have. And the more control, I would say, that this not-for-profit had over you, that's going to be a big factor. The more dependent you were on money made through this organization, that's going to be an important factor. So as I say, there's a good chance you would be entitled to severance, even though you may think otherwise. And I think if you're in the process of suing now or serving papers with the help of a lawyer on this company, I would include both the issue of back pay, of course, as well as severance or any other entitlements that your typical employee would get, whether it's vacation pay, severance, continuation maybe of a benefits package you were on. You wouldn't want to leave any stone unturned, even if it may not entirely all be possible. But yes, I would pursue the severance, it seems like. But I think it would just be a matter of fleshing out all the ways in which you would be more likely viewed as an employee versus this, so-called independent contractor. I've got another question from Richard Roper on YouTube, who's asking whether or not severance is paid based on previous year's base salary or if it includes overtime. And yes, overtime should be included. I think if somebody has a history of continuously working overtime, then that needs to be factored in when it comes to severance, because had that person still worked there, they likely, based on their history, would have also continued to work overtime. So if your employer is choosing to only pay you based on your base salary alone, and they're not really including overtime or average overtime work, they're not including bonuses, they're not including other items that you received while you were there, you want to make sure that you try to include as much of that as possible, again, so that you don't leave any stone unturned. And it may be the case that you have a better ability to get X, Y, Z and less to get A, B, C, but you should be including everything in there. And it sounds like if you continually work overtime, that absolutely has to be factored into the severance. I've got another question from Casey on YouTube, who's asking whether or not trade union representatives are more likely to experience victimization or retaliation, and are they more legally protected? So I answered a somewhat of a unionized question earlier. I'll just repeat it to say that I don't specialize in the union sector, Casey, so I cannot answer your question, but I would also probably defer you to who your union rep is, or who you would typically report to if you're on the union side, to get some more answers and some more information there. I've got another question in from Raccoon, who's asking or saying that the administrator verbally stated on 3 occasions that they don't want his wife or their wife and that person working in the same department. Appears to be a possible human rights and marital status issue. I would say that's a possibility. I don't know what the specific reason is on their end for not wanting you two to work together, if it's a productivity issue. But of course, if somebody is being treated in a way specifically to do with marital status or disability or gender or sexual orientation, whatever we're talking about under Human Rights Code, there's always that possibility. I think the question would just be how to prove it exactly, what evidence you have, and as I say, what their position is when it comes to you two working in the same department. I would suspect that if you're able to do your jobs, both of you, there shouldn't be any reason. But yeah, I think involve a little bit more fleshing out there. And again, just another reason why I think you should give us a call, and we can talk through all these issues with you. Sorry, one last from Raccoon saying that they cut pay 14.4%. Yeah, so that's another example of a constructive dismissal, big cuts in pay, and 14.4% I would consider to be a big pay cut, along with maybe the other issues that could all come together to build that constructive dismissal case. So just, I think, more things to consider. One last question before I leave everybody. I've got one from Alexander on YouTube, who's asking, how long does it take to settle for severance after you speak with a lawyer? That question is hard to answer. Usually my approach is, for the most part, to try to settle without the need for a lawsuit. If you can do that, get something fair and reasonable, it's entirely possible to settle within a month, 2, or maybe 3. If you can't and you have to sue the company, then it's much harder to predict how long it'll take. It could take a year. It could take more than a year, because it also depends on the facts of the case, how complicated the case is. Is it just a straightforward severance case? Are there other issues at play? Maybe human rights, maybe, other bad faith arguments. So hard to answer, but yeah, it could technically be a matter of months or potentially years, depending on how complex it is. But I would definitely get a lawyer to look at your situation, and based on those facts, probably give you a better idea as to how long it might take. Thank you, though, for everyone. I realize there's some more questions. I would definitely recommend you guys tune in to the next episode. If you have questions, as always, whether it has to do with going into a relationship, during a relationship, or after a working relationship, you've got it down below there, Tuesday, May 30th with Darren. So as I say, get your questions in. But as far as I'm concerned, it was a treat. Thanks, as always, for everyone attending. And I'll definitely see you guys soon. Take care. Enjoy the rest of your day. Bye for now.